Oh yeah, oh yeah. Cold outside, cold outside. Everybody hear there's more bad weather coming? Yep, more bad weather coming, kind of like bad information. Bad information in the world of social media. I know, YouTube, social media. Why are you complaining about social media? Well, I've got a whole bunch of phone calls, whole bunch of emails, whole bunch of questions. Now, this is what we like to call, or I like to call on CJTV, the special episode, the question. And this is done for the boys and girls and professional practitioners in blue, from the top of the food chain fed all the way down to the what one would consider the lower sector. Chats are open. Hit it. Throw a chat or two in. Throw a piece in, because we've got a few things to talk about. And keep in mind, CJTV is educational. It's that instructional period. Now, nothing is a replacement for a classroom, mind you, but society needs to learn a thing or two. Society needs to hear some things. Society needs to figure out that the God of media is not the true interpretation. Reality, concept, conceptual. When you're watching your favorite videos, your favorite people, you've got to understand that they're subject to the I think, I believe, I feel. There's nothing direct. It's all pretty much questionably exculpatory for the words that are coming out of their mouth. And when I say this, I imply it toward law enforcement, TV hosts, military, prior, present, whatever it may be, that think they are now political analysts, juris doctorates. There's a difference between a counsel, lawyer, and an attorney. Different practitioner fields, different practitioner specialties. So I've got a lot of questions on this, and I've heard a lot of different opinions. And I was asked to watch a whole bunch of social media today. Yay me! And so I got to hear the food chain of Juris Doctor, the food chain of political venue, the food chain of others that have opinions on protest, federal law, legislative construct of law, legislative enforcement, legislative instruction during applying adherence to legislative law. But everyone seems to forget or negate the top of the food chain and the relinquishment of the top of the food chain to hear 18 U.S. Code Section 231A3, which makes it a federal crime to willfully obstruct, impede, or interfere with law enforcement officers while lawfully engaging in their duties during a civil disorder, punishable up to 5 years in prison. And there are multiple cases to where this has happened. We're going to, review a few of them, talk about it a little bit. We're not, going to cover it politically, but this is the education half. Refusing a lawful direct command from police during such events. Remember, civil disorder. That is direct in the U.S. Code. 18 U.S. Code Section 231 A Alpha 3. Uno, dos, tres, 3. All right. Constitutes a violation for disruption. Failure to comply, resisting, such as orders to disperse, unlawful assembly, etc. The key details we have to take from this U.S. Code. Definition of the offense. The statute applies when someone commits or attempts to commit a crime or an act to interfere with law enforcement. Period. Done. Over. But during a civil disruption, protest, riot, whatever the disruption is, if it's unlawful. Now, we're not arguing First Amendment. We're not arguing peaceful assembly. We're not arguing right of, spoken word to be heard by those that are interpreting ideology, edict, rhetoric, and infusing the political mask to it. That's not what we're arguing here. The definition of the offense is civil disorder, an orderly protest, an orderly construct of a resistance, be it verbally, be it, semantically, physically, acoustically, just verbal, however it is, however the assembly that is lawful is assembled. That's not what we're arguing. The definition is civil disorder. It's not lawful. The civil disorder definition, this is critical, refers to any public disturbance involving acts of violence by groups or people which cause an immediate danger to property or persons in the vicinity, in the area, to include government officials and law enforcement. Yes, law enforcement too. including acts of obstruction, obstruct, or adversely affect commerce with the performance of federal function. Ooh, commerce, a federal function. Do not confuse enforcing the law with it's not a commerce. Yes, it's a commerce. Who's paying the federal law enforcement officers? It's commerce. Where does the money come from? It even comes from the protesters. Thus, that executive, legislative, judicial, you failed to do your job in the petition of orderly protest to swing a vote in your direction. Now you resort to something that is disorderly. Now we're talking about the law here. We're not talking about semantics of left, right, Republican, Democrat, conservative, libertarian. We're talking about a U.S. code and unlawful authority, lawful authority, action during the protest, action during the disturbance itself. Lawful command requirements. The command must be lawful and reasonable under the circumstances. That would be a lawful command from certified, post-certified, federal certified law enforcement. Someone that has been through training, the academy, whatever it may be, federal law enforcement officers training academy, other agencies, wherever it is, federalized, officer, stamped, dual bona fide, vetted on both sides. Law enforcement. Male, female, yes, all of it. The whole gambit. Elements of the violation. To convict, meaning to convict of the U.S. code. Yes, the government must prove failure to obey was willful and deliberate. Well, as I said before, I've been, tasked or requested by law enforcement and multiple people to watch a whole bunch of different videos and do my own research and do background research on specific things. When you have a historical venue of being at a protest unlawful and interfering with law enforcement officers, regardless whether it's at a state level or not, regardless whether one has permission or privilege by certificate, license, authority by the state, taught by the state, adhere to state requirements, there's still something called the federal government, because at that point in time, the Constitution, U.S. Code, United States Federal Code of the United States, let me say this again, United States Federal Code and section of the Republic of the United States, overweighs the state. Why? It's already there. So you can't claim that the Ninth Amendment, which gives privilege to the states for any type of permit, any type of, action, any type of authority, any type of privilege, outweighs U.S. Code and section of the U.S. Code, especially when it's been decided upon by federal jurisdictionary review, judiciary, meaning the federal appeals and the appeals of states that make it up to that level. So even though 18 U.S. Code section 231 alpha 3 A3 has really not received a bona fide, certified, vetted on both sides a decision by the Supreme Court, because the Supreme Court typically takes something that's a federal jurisdictionary appellate appeal that is conflicting two different federal jurisdictions, or within the singular, to where the definitive appeal appellate is confusing. It's not understood. And there's a risk of constitutional violation, or there's a risk of ill decision to affect the federal appeals process or the federal jurisdictionary judiciary review. The penalties, fines, imprisonment, we've already said that, 5 years. Who wants to do 5 years in prison for violating a U.S. section code? Under this code, passive resistance, while active resistance is generally required. You got to resist something, resisting, failure to comply, to be charged with it. Refusal to lawfully command during the civil disorder can constitute interference. Now, law enforcement, commanding, yes, that is part of it. So you're not going to charge someone with this federal statute unless the ability of law enforcement was not inhibited or obstructed. If the ability of law enforcement is inhibited or instructed for law enforcement to give a single entity, a group of, people, a mass entity of people, if the officer can't give the command, or multiple officers can't give the command because the protest, the disturbance, the whatever it may be, riot, we've had riots in the United States, it affects law enforcement's ability to command, because law enforcement is occupied with life safety, control, safety of society, safety of property, safety of themselves. Everybody seems to negate that. Law enforcement comes from society, so you harm in your own society. Executive, legislative, judicial. Remember, not grown in a garden or on a tree. The defense argument. Potentially, a defense may include that the command was not lawful, not reasonable, or that the individual did not have the intent to obstruct. Good questions of approach. But during the unlawful incident, also what must be argued is the intent of those that were willfully engaged in an unlawful incident. Lawful, unlawful. A construct that was not licensed. A construct meaning a protest, an assembly, a gathering, whatever it may be. Verbalization, physical action. Historical venue also has intent too, causation, direct evidence. Is one engaged in the defense argument of potentially defensible because the command was unlawful? When law enforcement sees that the entity of people or persons have already been previously encountered and it is documented, physical, assault, prevention of law enforcement doing their job, even though the one that would be the victim or the protester had received injuries, why did those injuries occur? Broken fingers, broken hands, broken ribs, treatment. It's set intent. It's arguable. So therefore, the command is not unreasonable. It's reasonable because the law enforcement officers are engaged in other duties, and yet the ones that are the aggregate of the unlawful incident reappear. This is argued under U.S. section and code. That's the dinger. A lot of people, forget about this. Now you're going to hear a lot of attorneys and a lot of, backyard garden scholars argue, well, this is only applicable to something that would be federal against federal officers. Oh, I negate thee. No, you're 100% wrong. Why? Let me help you out with a numeric and an alphabetic. J6. Yep, that happened. Sure did. We're going to cover that. Don't worry about it. But like I said, this is not political. This is educational. Even for those that are pro whatever side you on, it's good to know this. There's not a significant United States Supreme Court ruling on this, as I stated. Stand by, I got to get my shotgun mug coffee. Now, there's not a, Supreme Court decision on this directly. There's no interpretation because the definitive rules of the lines are, continuously argued under 18 U.S. Code Section 231A3. While the Supreme Court has been asked to review multiple cases, we're going to cover a few of them. We're not covering all of them, but I'll give you some good examples involving the statute, most notably the 1970s, Chicago 7. The Supreme Court has consistently denied, quereo terror, which means refusal to hear the case because of the definitive ill interpretation of the federal districts. Nothing's certain. Nothing's concrete. Why? Because in the actual code, in the actual statute itself at a federal level, it's unclear. But yet it's been argued in the past for those state level and who have trespassed over from state to state. When I say trespass, I don't mean illegally, but I mean trespass from state to state or city to city, different venue with intent to aid in disruption. Got to understand these things. So let's go to the magic screen. We're going to pull this up. We're going to go to another section so everybody can see. Here it is right here. Take a phone. Take a good snapshot. Chapter 12, Civil Disorder. You can, kind of review it for yourself. I just wanted to, give everybody an idea. This actually does exist, and it has been used several times in the past 4 years. Yes, the past 4 years. I know, critically scary. Let's move down. Let's move on for a little bit. Chats are open. Let me know if you're in the chat. Throw me a thumbs up. Nobody in the chat wants to. You don't have to. I'm sure you'll pick this up later. Related considerations. Unlawful assembly. The U.S. Code. State legislative rule. Responsibility. generally requires resistance from the one that is charged, refusing the unlawful command, the definitive arguments. But when one has been documented at a location multiple times and has received injury and has got that injury attended to, and the injury was caused by interfering with law enforcement, now you've got a problem. Now this code does apply to U.S. level, so therefore it supersedes the state legislative level. Argumentative? Yes, I know. No U.S. Supreme Court decision. We've got that. Under the lack of the U.S. Supreme Court case, it helps to look at the text. And the text under this is Section 231 as part of the Anti-Riot Act passed in 1968. Subsection A3 makes it a federal crime to travel in interstate commerce or use any facility of interstate commerce with the intent to commit any act of violence in furtherance of a riot. Interstate, intrastate, two different words, two different definitions. Think business, think commerce. Intrastate. So let's change the screen so that we're being educated here. Intrastate versus interstate. And this is just common. I know. Whoever this clown is, pay him no attention. Interstate refers to activities like commerce, transportation, or travel that cross state lines, while intrastate refers to activities that occur entirely within a single state's borders. Now, when you're going to this section and you're reading this, remember that two difference in terminology applies when someone commits or attempts to commit an act to interfere with lawful orders, officers during a civil disruption, civil disorder, or whatever it may be, riot or protest. But under the actual application of this code itself, applies to someone commits or attempts to commit an act of interference with law enforcement officers and immediate danger, damage to property, including acts of obstruction or adversely affect commerce of the performance of the federal function. Oh, here's the key. Affects commerce of the person who is performing the act of the federal function. Interstate travel, intrastate travel. Interesting. So the years that we hear this, the arguments that we hear, people coming from other locations, going to other locations to jump into the rally of the follow the riot, follow the parade, follow the protest. Interstate, crossing state lines. Intrastate. We've got to understand the differences in this, what it is. But yet, the argument of the federal level has not been decided upon by the United States Supreme Court. And we're going to get to these examples so that you will understand that there's a problem here. When you hear judiciary review, you're watching social media and you're hearing duty to warn, responsibility to warn, responsibility to assume, responsibility to recognize negligent behavior. U.S. Code, U.S. section. You're not hearing anyone argue about this, but yet you're hearing the Department of Justice throw it out there, a known agitator, a known terrorist. This is where it's coming from. Congratulations. Now we're picking up on something. Now we're learning something. So really, technically, the state and the legislative body of law have no context here. There's nothing there because of the definitive lack of definition and the ability to use this. United States versus Dellinger, 7th Circuit, 1972, holding court largely upheld of the constitutional or constitutionality of the act. All right, the relevance to A3. And this is a, United States versus Dellinger, Dellinger. Okay, not Dillinger, Dellinger. The court analyzed the requirement that the government must prove the defendant specifically intended to further riot through violence. The government has to prove that. Well, in specific cases to where the government can prove that someone has interstate or intrastate, even though it says interstate, but the United States Supreme Court has never really came up with a, opinion on this, but this is part of the Riot Act too. Is support being received from intra to inter, or inter supporting the intra of the state. Now, we've all heard the arguments that would be argued legally by definitive law, and it applies right here. So, one must be shown that that intent, that guilt is there, that one is participating. But when one has been injured in the hospital due to previous conflict with those acting in commerce of federal responsibility of law enforcement, there's your argument. There's one of them at least. And I was asked to kind of do this by some people, so give me a thumbs up if you're liking the content here. We're not taking sides. We're covering judiciary review. We're covering executive order and decision making to enforce this. United States versus Munchell, District of Columbia, D.C., Columbia, the United States. Has a ring to it, right? Washington. Circuit 201. This controlling precedent for modern application of 231A3, particularly regarding the January 6th Capitol event. Now, here we go. Intra and interstate. The dual. This section was used in the nefarious, notorious, legendary J6 thing. This was used. Why do you think the long overreach bearing fingers of what one would call the government was an argument of the long overreach bearing? Because this was used. Anti-riot, anti-protest, unlawful assembly, impeding federal Capitol Police from doing their job. It was used. Do your own research. And I'll bring this code back up. Oh, never mind. It's right here in the ticker as it's going by, right? Special episode, date, conceal carry, and the U.S. Code. 18 U.S. Code section, that little crazy SS thing. Okay, it's not a nefarious evil thing. Section 231 Alpha 3. Read it for yourself. I just pulled it up for you. Now, the J6, controlling precedent for modern application. The context. Defendants argued that the term riot was unconstitutionally vague and that their presence at the Capitol was protected as a protected protest, not a riot. Holding, the D.C. Circuit upheld that the statute against vagueness was challengeable. Interpretation, the court clarified that the function of 231A3, the government must prove. So the government had to sit there and prove it. Now, that's, the argument of, partisan side, partisan select, who's in charge at the actual time. The defendant traveled in interstate commerce, not inter, shifting. It's an argument here. There was a riot defined by the section code. The U.S. section code is a public disturbance involving an act of violence by a group or groups. The defendant acted with specific intent to commit an act of violence, furtherance of the riot. Interstate, not intra. So now you're adhering to the definitive word with no argument at a U.S. Supreme Court definition. Now, I know some lawyers or some, super garden-bred attorney with a few years of experience or 20, 30 years of experience is going to argue this. And, well, that's great. Argue it away. You can argue all day long, give your I think, I believe, I feel. It's not even a scholarly opinion when the United States Supreme Court has never set a precedent on it. And it's questionable with this, the impedance of law enforcement at a federal level or state level or county level or city level. Even though one would read the code and say, well, it's, specifically states federal a lot. And First Amendment protection of the court emphasizes that the statute does not criminalize mere advocacy, the mere presence at the peaceful protest. But the intent is what's argued. The intent of the disturbance, especially when one is documented causing the disturbance, receiving injuries themselves while aiding the mere advocacy against federal agencies from under commerce by this federal code from performing one's job. Now you got the double-edged sword of Damocles hanging over your head. Everybody's worried about a Second Amendment, clause here, a concealed carry, a right to carry, a duty to inform. Take that small potato beans and throw it in the corner. You're worried about small little anthills. To understand how 18, right, U.S. Code 231, right, Section 231 is applied, it is helpful to look at both historical examples, okay? The hypothetical scenarios, right? The template for definition. This statute is especially known as the Anti-Riot Act, which we've, actually covered, and it acts as a federal hook, like a worm on a hook. It's a mousetrap. It's a grabby. It's a grab-all. One would argue it's kind of like RICO because of the mass extension that one can reach for interstate. But if intrastate is involved, and the one that would be the acting party intrastate that aided through advocacy organization of those arriving intrastate into the intrastate, there you go. The intent, the hook, to charge individuals with local violence across state lines. That's something that's been argued in appeal courts, especially in the United States versus Munchel, D.C. Circuit, United States versus Dellinger. Both of those support intrastate with those that are interstate. It's a multiple hook tie, just like RICO. So when you hear all these lawyers on all these super shows and all these cops and all these professional know-it-alls and all these, social media, gab out tappers on opinions of I think, I believe, who are you going to listen to? The ones that actually know the executive scripts as being voted into the legislative to create law for the judiciary review, or the, I think, I believe, I feel. You're arguing at simple state levels. You're not arguing at the hierarchy level. You're not arguing at the top of the food chain of executive, the top. We've covered a few, historical. We even covered the J6. I don't want to go too deep into that because that implies, political adherence or political direction, which I'm not. I'm all about what the judiciary review says under the legislative construct of law that is written by the executive body of any side that lobbies to vote someone into office. That's where our attention needs to be, not on who did what. It needs to be on who's creating the actual law that affects us. The quick reaction force, so to say. Those that represent us when they're voted in, make a new law, the quick reaction force. Not to be, confused with, the term that military or law enforcement or other entities of society. But one thing that's critical here too, and I'm going to go back to the January 6th stroke of the problem. Okay. Even with that, all right, the situation, the members, the oath keepers, everybody's heard of that. The old guys that vanished that did a lot of keyboard super stuff. Yep. I said it. This guy said it right here. This guy, remember. The oath keepers traveled from states like Florida, Virginia to Washington, D.C. There were oath keepers in Washington, D.C., residents of Washington, D.C. So now you have intra, now you have intra, the support, both sides. All right, the support. But in scenarios that we're having today in 2016 in specific locations, we have the same assistance with commerce of the unlawful assembly, the protest, the riot, whatever you want to call it, whatever it may be, as the media would call it, mostly peaceful protests, throughout the city, but one area it's not. Documented injury, interference, commerce, and the U.S. Code specifically states commerce of federal law enforcement agencies to enforce their duties, their jobs, perform. It's already been documented. One has already interfered. Now, second interference. Now you're known. So when you hear the DOJ refer to a specific person or an entity as a threat, a terrorist, part of an organization that does interfere with commerce of federal agencies. It's not the I think, I believe, I feel of a lawyer or a entity on social media giving an opinion that is non-validated and has no credibility or reliability because there's no set precedence on it, because the federal appeals argue too much and the U.S. Supreme Court hasn't even given an opinion, let alone a decision. So now you've got the aggregate of inter. Everybody's worried about a state thing. That's second. Let's see what the chat's got going. See, question. If travel to a different state to join a protest and the protest gets violent, could I be charged with a federal offense, or is that only if the protest interferes with federal leo? Well, that's inter. So, if you're supported, as I said, there is no United States Supreme Court decision. There is no United States Supreme Court opinion. The United States Supreme Court will not hear an argument on this because federal conflict of appellate court, the confusion. But historical venue, those that have interstated to intrastate support, yes, have been charged. Yes, they have. So if you leave to go do that, this is something that could be swung over your head like the double-edged sword of Damocles. I just gave you two examples. It exists. Everybody's heard of the J6 scenario. It happens. And we're not arguing political venue. And there's more than just the J6, the Chicago series. And, there are other entities. And stand by, I'll pull this up real quick, and I'll actually give you the hypothetical. Here it is right here. The agitator, the clear violent, okay, the hypothetical scenario of boundaries. A group of Californians created a plan to disrupt a political convention in Ohio. They rent a van, drove from California to Ohio to bring bats, rocks, and shields. Before they leave, they text each other saying, "We're going to go smash windows and fight the police and shut down the event." Interstate travel, California to Ohio, text phones, proven. So, if I travel to a different state to join a protest and the protest gets violent, if you're, based on what you asked, if you participate or act in a manner that is under probable cause, direct knowledge, arguable suspicion that a crime is being committed, about to be committed, or has been committed, and if you're there and the officers, under probable cause, your actions can articulate that there is a belief that you were aiding, yeah, you can be charged. Sure can, all day long. Sure did. All day long. The peaceful traveler violation does not apply here. You traveled with intent. If it goes bad. Scenario 3, we're going to cover this one because this is a good one. The escalator kind of would apply to your statement if you travel. Well, why did you travel to go to a protest? What was the intent? What did you take? That's key. That's critical. That was one of the things that was argued against the Oath Keepers, Fillinger, the J6, the equipment in hotel rooms, the equipment in vehicles. What are you taking? What is the intent? Kind of like the California, right? The one that we just talked about. California to Ohio, you're traveling. But if there is interaction, if you're supporting the interstate commerce, you're aiding and abetting the interstate travel. And if you're supporting those that are coming from other interstates to intra, look at that. Conspiracy before and after. Aiding and abetting. So this last one, the escalator. All right. A student drives from Texas to a protest in Arizona. The student has no plan to commit violence whatsoever. None. Peaceful lunch with the squirrels and the fairies and lettuce. Upon the arrival, the student sees police using tear gas on the student's friends. In the heat of the moment, the student picks up a water bottle and throws it at a police line. Yep. Is that a violation? It's assault on a law enforcement officer. assault on the law enforcement, because even in the actual code, the Riot Act does not protect just federal officers. It protects local, municipality, state. All law enforcement apply. All law enforcement. So if you think, oh, well, I'm cool here as long as they can't prove it, the local cops can't prove it, guess what? All they have to do is have someone assigned to that task force, have someone smart enough to understand this, what I'm trying to talk to you about right here, and that hook comes out that I stated earlier. Everybody's so worried about that lower level state legislative rule. You got to worry about the bigger one, the bigger hook, not the little hook. Analysis is not likely a violation. You throw a bottle because you're a student, you cross, but you're going to face charges. You still can be charged under this law, but with the actual, it's a water bottle, aggregated down, argued down. You guys know, common sense. It's going to be pushed down. It's going to be knocked down a little bit. Now, the interstate commerce requirement, all right, the most critical element. This is the most critical argument that one would argue for local and non-local to both be recognized, investigated, and possibly charged for aiding and abetting in this under a federal rule, all right? Prosecuted, convicted, sent to prison. And I think everybody would understand. We're not arguing any sides here, but January 6th was the fantastico. And it wasn't just, a lot of people from one specific side. Hate to break the eggs over your, rainbowed shoulders of, oh, it was our side. No, there were multiple people arrested for acts on both sides of the partisan spectrum. Do your own research. Do it a lot. Now, the most critical element is the judiciary hook, the grab and sink you, pull you in, not let you go. The federal government, to charge you under this law, they must prove you crossed state lines or used a facility of interstate commerce, like a phone, internet, something to set the function or to facilitate the travel. And it applies to those who aid and abet in the function of those to facilitate the travel. So if you're known as an associate to those that are interstate and you're aiding and abetting interstate in the intrastate, congratulations, aiding and abetting, facilitating the 1-1-1 of all law enforcement and all charges, conspiracy before and after. That's how it applies. So, yeah, who is it? Big boy of the corn. You're going to get, you're going to get to see this fantastic U.S. code swung in front of your face if, God forbid that ever happens. I hope not. I hope you're, superstar or more intelligent and, you're not going to do something like that. Come on. It's common sense after we watch this show. The prosecution hurdles are severe. The government would need to prove you brought a gun specifically to use it. Right? That's an example. But if you claim you're carrying in self-defense where it's legal to, it creates reasonable doubt that you had specific intent. Now we get to the concealed carry, Second Amendment, the argument of, well, I've got, the right and the privilege to wherever I want to go with a gun to protect myself. Well, no, you can't take your Kalashnikov to Walmart and go shopping for your child's underwear and socks with a Kalashnikov hung over your shoulder. You're definitely going to be introduced to a lot of badges. And I hear a lot of, lights and sirens. And as society says, some people, I say joking manner, the wee-woos, they're coming. They want to have a conversation with you and possibly see your Kalashnikov, if not put law enforcement hands on it and minutia prints as they take it from you while they try to figure out why you need a self-defense weapon public displayed, not concealed if you don't have it concealed. Even if you're in a Second Amendment, what is the restriction of the actual item that you can carry? Yes, states have that. States that are open carry have that restriction. Another hurdle for one to argue. Exception. Facilitate the interstate commerce. Facilitate. The exception. Facilitation. Interstate. We're not talking about home, intra. This is a narrow scenario where protesting in your home city could trigger this statute. And it covers anyone who uses any facility or interstate commerce with intent to commit any act of violence. 231A3. It is covered as the exception. Facilitation. So if Bob calls John 2 states over or has connections with people interstate that move over into intrastate, this section can be used against them. The effect of commerce for law enforcement, against law enforcement, impediment. Look this up for yourself. Hold on, I don't have it up, but look it up for yourself. It's not rocket science. It is not rocket science. U.S. code, it's right here, down on the bottom, ticker. Now, alternative federal charges. Interstate, being aided by intrastate, it is listed under the exception to where one can be charged that is not primarily intrastate, but they're intrastate aiding and abetting in the intrastate travel, especially when one has multiple contact points in their past with law enforcement. And it's kind of sad that you're already documented having that, and then you've received injuries. Other people have received injuries, and medical documentation at hospitals, ERs for treatment, and one returns back to it thinking that that stomping ground is okay. It's not. There's something this big double-edged sword of Damocles. Now think about this. If one gets injured, hurt, or God forbid killed, those that were aiding intrastate and the interstate travel can be charged with this as conspiracy before or after, cooperative. You've got to use your head and wrap your head around this. That is why it is known as the hook. You have the DOJ. The DOJ is not one single entity. Everybody hears the DOJ and they think it's one bathroom closet and, a hallway in a big building that has DOJ stamped on it. No, it is multiple agencies under the umbrella blanket of Department of Justice, multiple departments. Think police department with divisions, patrol, detectives, canine, whatever, stop sign police, gopher recovery, dog cat recovery, whatever it may be. The DOJ has multiple entities. That's why it's the hook. Inter, connection. The summary of how it all works. It's the hook. In your home city, the statute likely does not apply due to lack of jurisdiction. In your home city, if you're not facilitating as an intrastate individual, interstate. So if you're facilitating it, that's the exemption, that's the hook. Period. With a gun, with a baseball bat, with words, with a syringe, with a glass, with a it doesn't matter. If it interferes with the commerce of law enforcement, obstructs law, and it actually breaks it down in the section because it's influenced by the Riot Act all the way down. Federal, all the way down to municipality and county, state, however it would be. Any law enforcement, if it's certified law enforcement with a badge, period. Game warden, constable, same applies. Same applies. So let's go to something here. I want to break something down for everybody so everybody can see this. And I got a lot of questions on this too. A lot of it. And I just kind of did like a fast note on it because I didn't want to bore anybody to death here. But right here, I got asked, is there a duty? Is there a duty? Is there a duty? States where you must inform law enforcement: Alaska, Arkansas, California, Washington, District of Columbia, Hawaii, Louisiana, Maine, Michigan, Nebraska, North Dakota, if carrying without a permit. That would be under legislative jurisdiction of, open carry, non-carry, carrying, just kind of, compare it to a state that's an open carry, but to carry concealed, you got to have a concealed carry. Compare it to that. Michigan, Nebraska, North Carolina, North Dakota, same as South Dakota, Texas. Failing to notifying these states may result in citations, permanent suspension, or even criminal charges. That's critical key here. It's very critical. Where one must inform. Now let's break the bubble and break hearts. Always like to break the heart. Let me shift this down so it's looks more smooth so that when hearts break and tears happen, it's why you're looking at a smoother screen. States where you only inform if asked. Arizona, Florida, Illinois, Kentucky, Minnesota, Missouri, New York, Oklahoma, Ohio, Oregon, Pennsylvania, Tennessee, Virginia, Washington, Wisconsin, and Wyoming. If you're not legally required to disclose, consider doing so. Yeah, I would, that's kind of my, thought for you. That's why I put it here. Consider it. Because if you're not doing anything by layman terms wrong, if you're not doing anything that would violate 18 U.S. Code Section 231 A3, Alpha 3, for all you military and alphabetic cops and superstars, Alpha 3, always got to get the tactical in it. If you're not doing anything wrong, there's no reason for you to disclose, no reason for you to consider. And even under that, if one's had prior, interaction with law enforcement, don't you think law enforcement would already have you flagged? Which in several cases, especially the most recent one, the person was flagged. They knew because of previous involvement, the commerce. Yes, and it's listed in the U.S. Code as the commerce